All righty. Good morning, good afternoon, those on the East Coast or anywhere else in the world. Welcome to this webinar on the Michigan Telephone Solicitation Act. Still early, so we're going to let people come in. We've got a lot of people registered for this topic. It's a hot topic, and we are excited to talk to you and share with you, what's going on. We're going to break down this new proposed bill. Again, my name is Arvell Craig. I'm here with Eric Troutman from TCPA World, the Troutman firm, and I'm with Contact Center Compliance. And we are excited to talk to you and walk you through this new bill, which is very interesting, is very different. And Eric's going to break it down for you all. We planned for this conversation to go maybe 40 minutes. We might not take the whole hour, but if you have questions, of course, always feel free to type in the chat box or feel free to type in the Q&A, which kind of has it a little more organized than putting in the chat box. But whichever option works for you, make sure you ask your questions and we will do our best to answer them on the call. But again, we're definitely not going to go longer than an hour. We'll shoot for 40, 45 minutes, but it depends on how many questions there are. So, yeah. It's just going to give it a few more minutes. People are still coming in. I see my question box popped up. Yes, as always, we always send out the slides after the event is over, and we normally also post them on our website, dnc.com/webinars, and you will find it. All of our past webinars, all of our past slides will be there. Yep, no problem.
Although, Arvell, this one's gonna be a little different, because there's not actually going to be slides.
That is true.
We're gonna walk through the bill together is what we're going to do for this presentation. So it's going to be a little different.
Thank you for that correction. So we will put a link to the bill or we'll put a link to TCPA World, which has some notes as well already about the bill. So that'll probably be in the, so we have the video replay, which will be posted on our site. And then it'll be a link to the actual bill and a link to TCPA World on their resources on the bill as well. Thank you for that. Yeah. Very cool. And answer that. 138 people. Very nice. So yeah, so let's go ahead and get started. I've got a few things I want to cover as well before we get started. Couple housekeeping things. The big thing is going to be, if I can jump over to the Florida TCPA Compliance Summit. As you can see on the screen, our next Compliance Summit will be December 5th and 6th in Clearwater Beach, Florida. So I highly recommend, if you want to get direct access to Eric and other attorneys and other compliance professionals, you want to register for that event now. The early bird pricing is open. Go to dnc.com/events, sign up for the event. It's going to be a beautiful 2 days. If you were at the Huntington Beach one, if you missed the Huntington Beach event, if you haven't heard about how amazing that summit was, it was incredible. So I highly recommend you to sign up. These events are unique. They're deep dives. They are comprehensive. They are condensed. There's lots of questions. It's TCPA, it's compliance all day, all night. We have some very interesting speakers coming. We have some, I think it's either an FTC or an FCC, or I think person will be there sharing some of their perspective on compliance and on the latest telemarketing regulation. So it will be a very unique event. So make sure you sign up, make sure you get in there and register now while the prices are as low as they are, before they go up and it's not going to fill up as far as the hotel, but these events are not huge. They are focused and condensed. So sign up now. That is one event. I wanted to make sure, and I will put a link in the chat if you need a link as well for that. And then we always want to mention, if you don't know about stoplitigators.com, this is our free resource for the industry as we go into Michigan and as we look at, from Oklahoma, we know about Florida, we know all this things that are happening with TCPA litigation. We want to make sure that the whole entire industry supports the entire industry by posting and sharing when you get a demand letter. If you're having questions about if your data is clean, you can use our litigator database for free to test it out. You can clean your data for free. You can post and share the phone number, share the information. It is private, it is secure. There's no personal information that ties back to you. We clean out the data, but we want to make sure that the entire industry supports the industry by fighting back against predatory litigators, by posting and sharing information on stoplitigators.com. If you haven't signed up for it yet, if you haven't used it, make sure you check that out, because again, every person who uses it, it does help the entire industry. So that is all I have to prepare. So I'm going to stop sharing my screen, and I will pass the mic to Eric Troutman, the czar of TCPA world, the Troutman firm. Eric, welcome. Let's get talking.
Yeah, Arvel, thank you so much for putting this together. And by the way, thank you to all of you, 155 people who are sitting here watching this. Like, we put notice out on this like 2 days ago. And I love it. I love it that you folks have answered the call and shown up in such numbers. I think it's great. Frankly, I didn't know how many folks were going to be here, but I'm glad that you're all here. I'm going to share my screen, and I'll tell you, one of the reasons why I'm really glad that everyone's here is that I really think this new TCPA, the Telephone Solicitation Act in Michigan, really, it might be the future. And I say that because, I mean, the Florida bill that is now the law, the FTSA, you've heard me criticize it multiple times as unconstitutional. It feels kind of slapped together, frankly. A lot of the terms don't make sense. The exceptions are like exemptions to exemptions unless this other exemption applies, and then there's no exemption. It's like, what? Right? It's very circular. It's just, frankly, it's not very well thought out. It's like slapped together. This Michigan bill, as we go through it, this is different. It's a horse of a different color. Somebody, or more likely somebodies, who are quite knowledgeable and quite thoughtful, spent quite a bit of time on this bill, and you're going to understand what I mean as we walk through this together. This is not, some goofball political stunt to try to get, reelected because, we're hot on robocalls. This is a thoughtful, very comprehensive, and dare I say, pretty well balanced effort to regulate outbound calling, and particularly sales calls. Now, some of this is going to apply more broadly than sales calls, but primarily this is about sales calls. So it's something that we all need to pay attention to, because again, it's more sophisticated, it's far more comprehensive, and it, to me, feels like the future. And by that I mean it feels like something that other states are likely to copy. I don't think it's any coincidence that the AGs are on their anti-robocall task force, right? The state AGs are doing all across the country, are getting together to put together plans to fight robocalls. And the state that's taking the lead in that is Michigan, right? The Michigan State AG is like the #1 AG pushing this forward, along with Ohio and Indiana. So I don't view it as a coincidence that Michigan is now going to have this very nice piece of, I'm saying nice, meaning well crafted. Not that I agree with it from a policy perspective. As we walk through this, you're going to see I definitely don't on a number of grounds. But it's well drafted, it's thought out, it's informed. And it is something that, again, I think the AG's office is working hand in hand with the staffers in the legislature that have put this together. All right. So I really think we need to pay attention to it. I do expect that it will pass. We do not know what the effective date will be yet if it passes. And it might not, right? I mean, who knows? Maybe we have this conversation and it never even passes. I think that's very unlikely, but it is not the law yet. I do expect it will pass, and I expect that we would probably see it on the books by probably November is my guess. And it is a guess. It's an informed guess, but that's a guess. But that's what I'm guessing right now. Okay. So let's start walking through this. And hopefully you all can see my screen okay. I'll admit I am not a technical wizard. In fact, I am frankly pretty bad at technology. But I know how to use this little plus button to zoom in. So I'm going to zoom in a little bit here. All right, so I'm going to start at section 3 of the bill. What we're going to do is, I know this is a little different, but I'm just going to walk through the bill with you. I thought about doing slides, but they would have just been copying the bill over and over again anyway. So I figured I'll just show you the bill. What we'll do is we'll look at each section, and then we'll go back and we'll look at the definitions that apply, okay? So section 3 is very easy. It's right here. It's already highlighted for you. A person shall not make a telephone solicitation using a recorded message in whole or in part. So let's think about that. Okay, using a recorded message in whole or in part. So that tells us right out of the gate, okay, that whatever a telephone solicitation is, we're going to go look at the definition here in a second, but we cannot use a recorded message for any part of a call. All right, so right away, you should kind of start thinking that's a little bit different than what we see in the TCPA, right? It's a little bit different than what we see in the Florida bill, because it's not talking about a pre-recorded call. It's talking about using a recorded message in any form, in whole or in part. So that might mean even a pre-recorded snippet being played at any time over the course of a call. It certainly seems to contemplate avatar technology and things like that. So it's just, it's a small nuance, but it's something to keep in mind, right? This is a thoughtful, broad definition where they're definitely trying to swoop in any kind of technology that's making use of these pre-recorded calls. Now let's go up, okay? So we've kept this in mind. Now let's go up and look at the definition of telephone solicitation, because we're going to see this definition over and over again. So we're going to scroll up here, and we will see it. Kind of an interesting definition right here at O. I'm going to highlight. I can make this happen. All right, telephone solicitation, there's our definition right there, so O, means, so this is interesting right here, pay attention, except as provided in subdivision P. Okay, so we're going to get a definition, and then we're going to have to go read a different section to see what the exceptions are to the definition. It's not great, but we're sophisticated. We're going to get through this together. All right, so we're going to start with what is a telephone solicitation. And I'm going to try, if I'm fancy enough to do it, I'm going to try to switch over to green for this part here. All right, so this is a solicitation. Get back up here. For the purpose, okay, so it's a call made for the purpose of encouraging the recipient to purchase, rent, receive, or invest in goods or services, or make a contribution to a charitable organization. All right, so let that wash over you. It's pretty broad, but not really inconsistent with the TCPA, except for this contribution to charitable organization, right, which makes it a little bit broader than the TCPA's D and C rules. All right, so keep that in mind as well. This is going to apply to charities as well as to calls made to encourage the purchase, rent, or receipt or investment in goods or services. One other word in there that's a little bit different is receive, right? For the purpose of encouraging the recipient to receive goods or services. You don't see that word in the TCPA. You don't see that word in Florida. I'm not entirely sure, frankly, what it means. All right, so this is one place where it's like we're throwing in a word there that we haven't seen before. Something to keep in mind. If you've got any thoughts as to what it might be trying to drive at, look, share your thoughts. Put it in the Q&A. We can kind of talk through it together. All right. Second is for the purpose of encouraging the recipient to provide personal information. Okay, including but not limited to identity, financial, or preferences information, or to defraud or wrongfully obtain anything of value. All right. So again, a little bit different than what we're seeing in these other statutes, a little bit broader, the solicitation concept. Also, for the purpose of encouraging the recipient to accept or participate in any employment, whether temporary or permanent, contracting an investment or other income opportunity to defraud or wrongfully obtain anything of value. Now, this is interesting, this last part here, to defraud or wrongfully obtain anything of value. It's not clear to me whether that applies to every other portion of this or it only applies to some later portion of it. All right. In other words, a telephone solicitation call in Michigan, assuming this law passes, might include any offer of employment, which would make it very different, right, than Florida or the national TCPA. Or, okay, that's one read, or, and this is interesting, it could only apply to an offer of employment that was intended to defraud somebody, which is a little bit weird, right? So again, I did say this is well crafted, and I think it's a thoughtful statute, but this little dangling participle here, it's like, what exactly is this applying to? I think what they're trying to get to is an offer of employment is going to be included as a telephone solicitation. So that's something to keep in mind, okay? For the purpose of encouraging the recipient to accept a prize promotion, something to keep in mind, right? Hey, come join our, fantasy dream house sweepstakes. That is going to constitute a telephone solicitation in Michigan if this bill passes. And then for the purpose of encouraging the recipient or a member of the recipient's family to avoid liability, legal or otherwise, to defraud or wrongfully obtain anything of value. All right, so again, I'm not entirely sure what this section is driving at. It could be, a legal offer of services, or it could be some scam, right? like an IRS scam call. If you don't call right away, you're going to be in trouble with the IRS, right? So it's saying essentially you need to do something to avoid a legal consequence, but really it's being done falsely and fraudulently. All right. Again, it's a little unclear to me what they're getting out there, but I think this is only for fraud calls. And this last one is interesting. On behalf of a political organization, again, under the DNC rules, the TCPA, political calls do not constitute marketing, but under the Michigan rules, they would constitute a telephone solicitation. All right, so something to keep in mind. Now, things that are not a telephone solicitation, I'm going to switch to red here, although maybe I should have used red for the prohibitions and green for the exemptions, but whatever. So a telephone solicitation does not include, and this is the first one, it's very important, a telephone communication to a residential telephone subscriber with the subscriber's express verifiable authorization. Very interesting, right? Let's go back up to the top real quick. So remember, a telephone solicitation means a telephone communication. A telephone communication. Notice, a telephone communication is not just to a residential phone. It's a telephone communication, right? There's a definition up here. Telephone communication means a communication via telephone, including but not limited to any of the following: a voice communication, including but not limited to those made by an ATDS, an announcing device, a recorded message. Say, again, let's not get confused. A voice communication, including but not limited to, okay? So a telephone communication is any voice communication to a phone or a text message. What distinction am I drawing here? That word residential. Do you see the word residential in telephone communication? It's not there. Do you see residential here in the definition of telephone solicitation? It's not there, right? So unlike the TCPA that only applies to calls to residential lines, this applies to any line. Something to think about, again. But when you look at the exception as written only applies to residential telephone subscribers. Now, this feels like an oversight to me, right? This feels like a place where, again, I don't know, we've got a lot of attendees, maybe you got some staffers from Michigan paying attention. I hope so. If so, you got to close that gap, right? You've got a restriction that applies to calls regardless of whether or not it's to a residential line. But you've got an exemption that only applies to consent from residential subscribers. Okay, those two have to align. So either you need to limit the restriction or you need to broaden the exception. All right, so something to keep in mind, folks. Again, this is a draft bill. It has not yet passed. I do expect that they'll close that gap. But again, this is why we're walking through this together. If I just put this on a screen, you'd be like, what are you talking about? If you see it together, now you can kind of understand what we're getting at here. All right, so number two, again, these are the exceptions to what constitutes a telephone solicitation. A telephone communication to an existing customer of the person on whose behalf, so existing customer, right, of the person on whose behalf the telephone communication is made, unless, okay, exception to the exception, unless the existing customer is a consumer who has requested to not receive communications, okay? So that's pretty obvious. You got an EBR, unless they've asked you not to. So you've got an EBR exemption working in your favor under the Michigan bill. That's great. That, as you can tell right out of the gate, that is a huge difference between Michigan and Florida. And that's why I say, like, this one feels a little bit more balanced, right? Because it's going to give you the EBR rule. Notice, if you have an EBR, boom, it's not a telephone solicitation at all. That's great, right? That's great, because now a lot of these restrictions, as we walk through them, are not even going to apply when you're trying to contact your own customer. So we can kind of start thinking about this bill then as less geared at regulating attempts to contact your own customer and more geared, and we're going to see in some instances, very geared toward lead generation, right? And toward outbound calling for prospecting and for origination purposes. All right, so just finishing up the exceptions to what is a telephone solicitation. A telephone communication made consistent with and not in violation of any law regarding debt collection, okay? So debt collection is, again, going to be treated as completely outside of the definition of telephone solicitation. Very important to keep in mind. Debt collectors out there, you can just go away now. I'm kidding. There's other restrictions here that might apply to you, but the definition of telephone solicitation does not apply to you. Now, if it's a little interesting to anyone that we're defining telephone solicitation and they're specifically having to exempt debt collection, you should think about that, right? Why would anyone think that debt collection is telephone solicitation to begin with? Like, why would you have to even have that exemption? But again, when we looked at the definition of telephone solicitation, that had that word receive in there, right? So maybe we're talking about receiving funds back from the consumer. I don't know. It's kind of a bit of a stretch. But I appreciate this exemption here to make sure that if you're a debt collector, you know that you're not doing telephone solicitation. And then finally, and this is very interesting, a telephone communication to a business telephone number unless the business has requested that it not receive telephone communications, all right? So I guess this is an answer to the gap we identified earlier, right? A telephone solicitation includes all calls to everyone, but then they exempt calls to business numbers, and they give a residential subscriber the right to consent. I guess this makes sense to me. I guess that kind of closes the gap. That feels a little clunky. It feels a little uneven. Again, I would go back and just kind of have the definition in the first instance of what a telephone solicitation is to say it is a call to a residential number, as opposed to saying it's a call to any number and then exempting calls to business lines and then giving a right to residential numbers, subscribers to consent. That feels like a kind of inelegant way to get to what they're trying to get at, but hey, we're walking through this together. All right, so hopefully that all makes sense. So we're going to come back down here now. We're going to switch back to looking at the restrictions. So, again, the first restriction is very, very clear. You cannot, again, make the telephone solicitation. We just walk through what that is using this recorded message in whole or in part. All right, so now we walk to section 5. This telephone solicitor shall not make a telephone solicitation. We know what that definition is. All right, now we're talking to a residential telephone subscriber whose home or wireless telephone number is on the most current version of the do not call list. All right. So there can't be any telephone solicitation prohibited to anyone on the DNC list, period, no matter how you're making the call. Now, we have some more exceptions here. It says that it does not apply to either of these, excuse me, I'm going too fast here. The following: a telephone solicitation made on behalf of a charitable organization. Okay, so earlier we saw that charitable organizations are covered in the definition of telephone solicitation, but now we're going to see that there's an exemption, at least as to calls on the DNC list in favor of charitable organizations. So this is going to go back and realign with the TCPA, right? So again, the definitions depart, but then the restrictions are bringing it back into alignment with the TCPA. As you can tell, this is very comprehensive. Someone spent a lot of time working through this and arrived at this as the most logical way of approaching these restrictions. It is different than the TCPA, but you're seeing, although it's written differently, it's starting to conform, right, with the federal statute. So a telephone solicitation made on behalf of a charitable organization is exempt, but only if the telephone solicitor is either a volunteer working under the direct supervision of an employee of the charitable organization or an employee of the charitable organization. Okay, so you can't have third parties doing this. Or the telephone solicitor who made the telephone call immediately discloses, sorry, it's an and, not an or, immediately discloses the solicitor's true first and last name. Okay. And you're going to see this over and over again, right? There's a lot of disclosure requirements under this bill. True first and last name, address, and telephone number of the charitable organization. And so you have to have these things here. Now, so that's one exception altogether, okay? Telephone solicitation made on behalf of a charitable organization if the call is made by a volunteer or an employee of the charitable organization and they disclose at the beginning of the call the solicitor's true first name and the name, address, and telephone number of the charitable organization. Another exception, political organizations. Okay, again, we just saw up there the definition of telephone solicitation includes political organizations. Now, again, with respect to calls to phone numbers on the DNC, we're going to see that these are exempted where political organizations are making the call. A person shall not include the telephone number of a residential telephone subscriber that is on the most current version of the and this is one of the downsides to working just through it, is that, we're not going next slide. All right, so Looking at the exceptions to the rules on calls to the DNC, charitable organizations are exempted if they follow these rules. All political organizations are allowed to make calls to numbers on the DNC, even though they still constitute telephone solicitations, okay? So with regards to political organizations, so far we know we can't use pre-recorded calls of any kind, right? Because that constitutes a telephone solicitation unless you have consent. But you can make a political call to numbers that are on the DNC list, even though they would constitute a telephone solicitation. Now, Section 2, this is a completely separate restriction, all right? So remember, we're in Section 5. Sub 1 was restrictions on telephone solicitations to numbers on the DNC. Sub 2, check this out, this is really interesting. A person shall not include the telephone number of a residential telephone subscriber that is on the most recent version of the DNC list in a lead generation. So if you are a lead generator, we're going to look at the definition of lead generation right now. You cannot include the telephone number of a residential subscriber in your lead generation effort if they're on the DNC. Pretty interesting, no? Let's look at the definition of lead generation. Let's scroll back up here. There it is right here. This is sub I. Let's switch over to green so we can see it's a definition. Lead generation means the sourcing, sale, subscription, leasing, renting, distribution, purchase, wholesaling, or transfer of a list of telephone numbers utilized or intended to be utilized for telephone solicitations.
Mm-hmm.
Now, it's very interesting. And again, I said at the beginning, I thought this was a well-crafted act. This is probably the worst part in terms of craftsmanship of the bill, because it is critically important to lead generators to know, does consent matter here, right? If the consumer has given express written consent, it feels to me that there's no telephone solicitation that could possibly be involved. So when you look at the bottom here, it has to be utilized for telephone solicitation because telephone solicitation removes consented calls, right? But when you look at the scope of Section 7.2 down here, Section 5.2, it says a person shall not include the telephone number of a residential telephone subscriber that is on the most current version of the do not call list in a lead generation. So the concept of consent doesn't play into the restriction here at Section 5 sub 2. So it's a little unclear to me if the concept of lead generation as defined specifically and intentionally exempts consented calls, or that is to say people who have given consent to have their numbers be contacted, or not. Again, that is something that's very important to know. It feels to me, reading it all together kind of comprehensively, that was the intention, was that this is essentially trying to prevent people from creating cold lists and selling those cold lists, right? Like, I'm going to generate a list of data sets of people that I think might be homeowners, and I'm going to sell those to folks that are selling solar panels, right? I think it's designed to prevent that sale, right? So now the lead generator is themselves responsible, right, for any subsequent calls by that solar company. I don't think it's supposed to apply to people that have a website, solarnow.com, where people come on and they provide their phone number and they provide their name and they say, I'm interested in solar. I don't think so. But again, it's a little bit unclear in that respect. All right, let me pause. It looks like there's a few questions, Arbel. Anything we should address now?
Yeah, let's see. Let's go through some of these. Well, starting from the top, when the first thing you mentioned was on the call recording, and so some people were just trying to understand, like, what about a recording that says this call may be recorded? I assume that's a recorded call, but that was.
I think that's pretty straightforward under the language of the bill. I think that would constitute the use of a recording in a telephone solicitation. So that's right. You're gonna have to stay away from that.
Yeah, like we do manual calls, but we use pre-recorded messages. If we get to the mailbox, let me see. So yeah, yeah, you said it's part or whole. It doesn't matter if you don't have the consent for it, there's no way to use it. Okay. Say a person shall not make a telephone solicitation using, same thing. Okay. Yeah, again, I think we kind of covered that. Does this mean pre-recorded message? Please hold while we connect your call.
Yeah,
Anyway.
that's gonna count too, guys.
Yeah.
I mean, as defined, any use of a pre-recorded voice or a recorded voice for any purpose. There's no exceptions. I mean, we read it together. It's very stark. It's black and white. On the one hand, I like that. On the other hand, it does lead to absurd results. So keep this in mind. Okay, so keep monitoring for questions, Arvel. Let's keep moving through here.
Yep.
Still a lot more. We've barely scratched the surface of this bill so far. All right,
Yeah.
so section 7. Now this is something to keep in mind, right? These disclosure requirements. I think this is going to be really some of the heart of this bill is disclosure requirements. So let's look at section 7. At the beginning of a telephone solicitation, the organization or other person on whose behalf the call was initiated shall ensure that the telephone solicitor states the telephone solicitor's true first and last name and the full name, address, and telephone number of the organization or other person on whose behalf the call was initiated. All right. So a couple of things I want you to notice here. First, the responsibility to assure that the disclosure is taking place is on two people. First, it's on the organization on whose behalf the call was initiated. Okay. They are to ensure that the telephone solicitor, who seemingly also has the responsibility, right, states the telephone solicitor's true name. So it's not just the telephone solicitor, right? It's not just the marketer, the call center that has this responsibility. It is the organization on whose behalf the call was initiated. So again, it's not 100% clear, but it feels to me very much that in a situation where you are selling, I'll just keep picking on solar, poor solar. You're selling solar panels, and you have a call center out there. It's a third party, and they're out there making outbound calls to sell your product, right? You, as the product seller, have the responsibility to assure that that call center is disclosing, right, who they are. And let's look at what they have to disclose. The solicitor's true first and last name and the full name, address, and telephone number of the organization or other person on whose behalf the call was initiated. All right. So again, it seems to me that if you are using, Bob's call center to sell John's solar, what this requires is probably a disclosure, certainly of John's solar, right? So the solar company is going to have to be disclosed, but it probably needs to be something along the lines of, hey, this is Jane Plain from Bob's call center calling on behalf of John Solar, right? That's kind of where you should be thinking about putting your disclosure requirements. But you definitely need it. I mean, it feels pretty obvious to me that you need to be referencing the company on whose behalf the call is being made. I know that's really hard, again, in the context of some lead generators, right? You're out there making calls to qualify a lead. You don't really know who it's going to be sold to, right? So that makes this really tough. And we've got to start thinking to ourselves, in Michigan, are the days of qualifying a lead and then trying to do a ping post or an auction and figure out who you're going to sell it to. Is that going to be consistent with this bill? Or are you going to have exclusive deals, or at least quasi-exclusive deals, where essentially who this lead is going to be sold to at the time you make the outbound call so that you can comply with the disclosure requirements? Something to keep in mind, all right? So now we move on to section 2. I know that there's a lot there. I tried my best to unpackage it, but we got to keep moving because there's still a lot more to get through. Again, the organization or other person described in section 1, okay? So again, the solicitor or the organization on whose behalf the call is being made, right, the seller, shall ensure that an individual is available to answer the telephone number that is provided at any time during traditional business hours between 9 and 5 p.m. Not the hardest thing in the world to make sure that you've got a telephone that is manned, right, on an inbound basis, but remember, you have to do that. And again, of course, you also have to have, again, as part of the scripting on sub 1, the disclosure of what that phone number is. So if you can imagine the script I gave you before, right? This is Jane Plain calling from Bob's call center about John Solar. our phone number that you can reach us at is 1-800 blah 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 blah. Not a tremendous consumer experience, obviously, that's being dictated here, but this seems to be what the statute has in mind. Then, of course, the phone number that's provided needs to be a real phone number, and somebody has to be available to answer it between 9 a.m. and 5 p.m. local time, by the way. So keep that in mind, right? If you're calling into Michigan, right, because this is in Michigan, they might be at the Eastern time zone. They might be at the Central time zone. Okay, that's one thing to keep in mind. And two, if your call center is in California, I don't know why you would do that, but if your call center was in California, you can't just be open 9 to 5 Pacific time. You've got to be open, right, starting at 6 a.m. to account for that 9 a.m. timetable in Detroit. All right, so just keep that in mind as well. All right, the organization or other person described in Section 1 shall ensure that the individual answering the telephone number under subsection 2 provides a residential telephone subscriber who calls the telephone number with information to describe the purpose and operations of the organization or other person on whose behalf the telephone solicitation was made. Okay, blah, blah, blah. What does that mean? The person that answers the phone on that inbound call needs to be able to say, hi, this is Bob's call center. We make calls on behalf of solar companies. How can we help you? Or the number can go straight through to John's Solar, and they can say, hi, this is John Solar. How can we help you? Right? Either of those two situations would be fine. Moving on to number 4, again, really important, guys, as we start thinking about DIDs. And I was just at the Convoso Roadshow yesterday. I'm not sure how many of you folks that are watching this were at that roadshow. And we were talking about DID usage in Florida and Oklahoma. Michigan also has some very interesting rules around DID. So we're going to pivot a little bit, right? We were talking about disclosure requirements. Now we're going to talk about a different kind of disclosure, which is how the outbound telephone numbers are appearing. A telephone solicitor shall not do any of the following: block, restrict, circumvent, or otherwise interfere with the subscriber's caller ID service so that the telephone number on the telephone solicitor is not displayed properly on the caller ID service or the subscriber. All right, no big deal. This does not say, what kind of DIDs you can use. It just means you have to allow your number to pass through. Hopefully, none of you are hiding your numbers or trying to, pretend that you're not who you are. So that's okay. That's pretty easy to comply with. This one too, right? You can't display or cause to be displayed a fictitious or misleading name or telephone number. Now, misleading name, that's easy. You're not gonna lie, right? I mean, you got a DBA. Is that misleading? Again, to the extent that it's a real DBA, it's not going to be deemed as misleading. Telephone number, right? If it's a real DID that's assigned to you, to me, that's not going to be a fictitious or misleading telephone number. It's a real telephone number they can call back. All right. Next one gets interesting though. Or to otherwise misrepresent the location or origin of a telephone solicitation or the identity of a telephone solicitor. Now, when you start talking about misrepresenting location or origin, right, and you start thinking about local touch telephone numbers, and the courts really don't like this, and I get it, right? And in Florida and Oklahoma, they're frankly a little more clear and direct. And as we work through the bill, there's even more on this. But if you've got a call center, right, that is in Oklahoma, and you're calling Michigan, right? You got to ask yourself, can I use a Michigan DID for this? Or do I need to be using only Oklahoma DIDs, right? Which doesn't necessarily make sense. Like, I get it, right? The DID is legitimate, it's live, it's actually better for the consumer because it's like a local number, they're not long distance when they call it back. But that seems to be kind of what they're trying to drive at here with this bill, is preventing folks that have call centers out of state from using those local DIDs. It's not as clear as like Massachusetts, right, where we know you just can't even use an area code from Massachusetts unless you actually have a call center there. But it is an interesting way of getting to the same point. Okay, we go to C. We got a little bit more here. You cannot use a third party to display, right, any of these things. So it's the same concept. You can't do it yourself. You can't have somebody else doing it for you. Again, and that means you can't have somebody apparently giving you a DID that is inconsistent with the place of origin of the phone call. And then again, you cannot use a telephone number associated with a direct inward dialing, that's your DID, or direct dialing system, or use a telephone number otherwise purchased, leased, licensed, or rented from a person for any telephone solicitation, again, here's the language again, that misrepresents the location of origin of a telephone solicitation or the identity of the telephone solicitor, all right? So you can see they're kind of building, right? First, it was kind of a little bit vague, and it's like you can't do it through a third party. Now they're kind of getting a little bit clearer, right? They seem to be saying the same thing over and over again with slightly different words, because they're really, again, they're trying to prevent the usage of these local touch DIDs from out-of-state call centers. And I'll be honest with you, I don't know why the legislators and the court hate that so much. I think they really get it confused with spoofing, right? Spoofing is, of course, using somebody else's number that is not assigned to you to try to trick someone to answer a phone, right? That's spoofing. A DID is assigned to you. It's not spoofing. It's not fraudulent. It's not cheating. You're just giving the consumer a number they can call you back on that happens to be in their area code, because it's, frankly, it's more convenient for the consumer. Of course, it also leads to the consumer picking up the phone more often. But for some reason, again, as you can see here, the legislators really don't like this practice. All right. Hopefully that all makes sense. So now we move to subsection 4 here, to section 5, which references section 4. Okay, so again, section 4 up here, right, deals with the blocking of or the use of DIDs and phone numbers, right? The subsection 4 here says it does not create liability for a carrier or for a VoIP whose actions undertaken for the purpose of complying with the wireless local number portability requirement promulgated by the FCC. Right, so there's a narrow safe harbor available to carriers and VoIP service providers. Again, that's interesting because I didn't read the restriction as applying to carriers or service providers. The fact that they put an exception to the restriction suggests that maybe it does. So I don't know if I have any carriers or VoIP service providers paying attention to this webinar. It might be that you're going to be directly liable if you provide DIDs to individuals who are misusing those DIDs. And again, misusing in this context is as simple as using a local touch DID when in fact your call center is not in Michigan. So it feels like, and again, it's going to take a little time for this to work out to find out for sure, both the call center is going to be liable as a solicitor, the company on whose behalf the materials are being sold might be liable, and even the carrier who's providing the DIDs might be liable unless it's being done specifically as part of a wireless number plan that's compelled by the FCC. All right, let me pause again before we move on to section 9, where it's going to get interesting again. Go ahead, Arvel. Anything that we should address?
Okay, yeah, there's definitely a lot of questions here, and I'm trying to figure out what's the most appropriate ones to ask. Let's see. Yeah, I don't know. Let me see. Read this one from Matt. It says, with a lead provider defined as the transfer of a list, do you think that real-time lead by lead transfer would fall under the definition? In that instance, no list is ever transferred unless you define the aggravate transfer. I don't know. Do you follow that question?
I do follow that question. It's an interesting question. Let's go back up and look at the definition real quick.
Yeah. Sourcing,
sale, subscription, leasing, renting, distribution, purchase, wholesaling, or transfer of a list of telephone numbers. I see what you're doing, right? I agree with you. A list implies more than one, right? Many lead providers are doing a single post, right, API kind of process that doesn't feel like a list. But then again, if you are doing that over and over and over again, what do you end up with? You end up with a list, right? So I like that argument. And again, this is something I told you before. I don't think this definition is very good. I think this is one of the most problematic parts of the bill, in my opinion. Unsurprisingly, it's also the first attempt that I'm aware of in a telecommunications bill to try to limit lead generation usage. So it's not surprising to me that, they're not, the folks that drafted this bill, the staffers don't really get it. Hopefully they're watching this and, maybe they'll provide some clarity on that point. That's a really good point. I think though, that again, the larger question is whether or not consented leads are gonna be okay. If consented leads are going to be okay, then of course in the ping post in the one-to-one API situation, it's not going to matter because you've got consent. If consented leads are not okay, I suspect that you're not going to get over the list hurdle by saying, well, we form the list one by one, but we don't know. So it's a good question. I like that question.
Okay.
Anything else, Arvell?
Yeah, one other question. Simple one here from Scott Schaefer. He says, does the statute provide a private right of action against lead generators?
Yes, it does. And we're going to get to that hopefully. In fact, I'm going to pick up the pace a little bit here. I'm going at a very kind of slow pace because there's a lot here. As you can tell, it's very dense. But I do want to. We're going to pick up the pace now. We're going to be a little bit more of an overview from here on out, as opposed to kind of a deep dive.
Yeah.
So let's move on now to Section 9. Okay. Section 9 says a person shall not do any of the following. Okay. Use an ADAD for a telephone solicitation that otherwise violates this act. Okay, we're going to look at the definition of ADAD, but this one doesn't really move the needle because it basically just says you can't do it for a telephone solicitation that otherwise violates this act. So since you're already banned from doing telephone solicitations that ban the act, I don't really care about this restriction. This is a dumb restriction. But B is not. It's a little different. Use an ADAD for a telephone solicitation unless the list of numbers from which the ADAD selects telephone numbers excludes both of the following. Okay, vulnerable telephone numbers and telephone numbers of subscribers who are not on the most current version of the do not call list. All right, so if you're going to use an ADAD for a telephone solicitation, you have to exclude vulnerable telephone numbers and numbers on the DNC. So let's look at the definition of ADAD, all right, because this will be valuable for everybody too. We're going to go all the way back up here. What is an ADAD? This is going to make you really excited, folks. It's Florida. ADAD, or automatic dialing and announcing device, means, and I don't know why they couldn't just say auto dialer or ATDS, by the way, had to be ADAD, means any device or system of devices, device or system of devices. Well, this is going to be broad, folks. That is used, whether alone or in conjunction with other equipment, devices alone or with other equipment for the purpose of automatically selecting or dialing telephone numbers. That or is there. Okay, so it's just like Florida. Any system used to determine the sequence in which any number is to be called is going to be an ATDS, right? Even if you're using a workflow tool, an ADAD, that's going to take me a while to get. An ADAD. Even if you're using a workflow tool on your computer that's telling you what account to work next, you're picking up the phone to dial, right, on your pipeline, that's still going to be an ADAD because you're using that computer to automatically select what telephone number is going to be called next, and that selection alone triggers the statute. Automatic dialing is not required because of that word or. And again, this is an exceptionally broad definition, probably even broader than Florida. I can't believe I'm saying that, because it looks at devices and other equipment that combine with those devices. So, I mean, it's just anything that's a computer that's providing you any assistance in determining what number to call next is going to be triggered. Now, despite the breadth of the ADAD definition, though, if we come back and we look at the restriction again, we see that the restriction is actually pretty narrow, right? Again, it only applies to, or it only requires you to remove vulnerable telephone numbers and people on the DNC list. Well, you shouldn't be making telephone solicitations to people on the DNC list anyway, okay? So that's not really going to move the needle much. But now we just know that we need to make sure that we are scrubbing out vulnerable telephone numbers when we're using our auto dial, all right? That is the essence of the Michigan statute from an auto dialer perspective. Vulnerable telephone numbers have to be taken out. Let's go up and look at the definition now of vulnerable telephone numbers so we know what we need to avoid, okay? Vulnerable telephone numbers are an emergency telephone number, okay? So you better not have any sheriff's office, police office, ambulance company in your list, right? And you know there's going to be trolls out there that are sticking these numbers in your list, okay, folks? So you got to be careful. Telephone number of a hospital, medical physician, or service office, healthcare facility, or healthcare provider, the telephone number of a governmental entity, or the telephone number of an educational facility, okay? all of those numbers have to be scrubbed out before you can use your ADAD for a telephone solicitation, right? But we have an exception here. Subsection 1 does not apply to a telephone solicitation made with any of the following. The telephone solicitation is made to a subscriber with the subscriber's express verifiable authorization. We've got a new definition, folks. Okay, let's look at this. So we are allowed to make calls even using an ADAD that constitute a telephone solicitation if it's made using an express verifiable authorization. You guys are going to like this. Look at this definition. It's not PEWC. It's a lower standard. Look at this. Express verifiable authorization means any of the following: a prior written authorization, a prior electronic authorization, or a prior oral authorization recorded by the telephone solicitor. Recorded, right? People are always asking me, Eric, can I get prior express written consent using a recorded call? And the answer to that is no. The recorded call can be a signature, but under the federal rule, you have to have a written agreement. Under the state statute, you will not have to have a written agreement. You can get a recording and oral consent, and that will be okay. Pretty good, right? So I'm saying there's a little bit of balance to this one. It's not so one-sided as we've seen in other places. Okay, so let's pick up the pace a little bit.
Okay, one small question. I don't know, as you're saying, this is a draft, and to me, it's kind of weird for this area to talk about those telephone numbers, which are all businesses, emergencies, hospitals, medical. It almost seems like it's a typo that it should be vulnerable individuals, not vulnerable telephone numbers. To me, that would fit more like DNC and vulnerable individuals.
I agree with you.
Okay.
And you might be right. And as you correctly point out, there's a separate definition here for vulnerable individual, right? Which is up top. And we'll see when we get down, I'm going to move down to the private right of action now. Okay. And you'll see the definition of vulnerable individual does play a role in the private right of action. But it means an individual who is 75 years of age or older, who has a disability at the time, as that term is defined here in the Disabilities Act. Okay. Yeah. So let's move kind of quick now. Okay. I've given you an overview of most of the restrictions. There are a few more. You know, again, as we kind of just scroll through here, you should understand that the content of your calls is going to be at issue, just like under the TSR here in the Michigan statute. You should understand that there's abusive behavior restrictions. For instance, allowing a telephone to ring repeatedly or continuously. Again, just like we see in the TSR, those restrictions now exist here. The UDAP rules, unfair, deceptive, abusive conduct, all of those are going to be restricted by the Michigan statute to a more or less, I would say, equivalent extent of the federal rule. However, remember, the Michigan AG might interpret their rule differently than the FTC interprets the TSR, right? So you've got pretty much the same rules, but how the FTC views what is fraudulent or unfair might not be the same thing as what the Michigan AG's office views as fraudulent or unfair. So keep that in mind, okay? And then again, something else to keep in mind, just like in the Florida bill, there's a restriction on calls from 9 a.m. You're only allowed to make calls from 9 a.m. to 8 p.m. local time. And again, you got 2 time zones in Michigan, okay? So keep that in mind. But better, again, than Florida is that if you have express verifiable authorization, you don't have to abide by that rule. And that's great, okay? So again, a little bit more balanced, not such a bad thing. Again, please, for those of you that are doing telesales as opposed to marketing, please understand there's a bunch of material here we have to skip over, unfortunately, in terms of how you can go about doing your sale. Again, it is very similar to the TSR, but again, we've got a separate entity now enforcing these rules. It might not be interpreted the same way. So a couple of other notes here, and I'm going kind of fast, but if you take a look here, the private right of action, sorry, not private right of action, an AG's enforcement action. Again, Michigan AG, very aggressive, folks, very aggressive. This is not a sleepy AG's office. They are all about now protecting consumers from what they deem to be robocalls, right? And again, hopefully, if the AG's office is listening, I know we've got some followers from the state AG's office, I mean, you guys are going to do what you're going to do, but I really hope that you're focusing on the real bad actors, right? The scammers, the folks that are really being abusive, and not the companies that are doing their best to comply with the law. They're legitimate American companies selling legitimate, right, legitimate things to consumers that they actually need based upon a good faith belief, right? They actually ask for these calls, right? Which in the lead generation context, you got lead buyers that are really just looking to talk to people that really want their products and they're paying good money for that. Hopefully the enforcement actions are going to go after the real bad guys, the IRS scammers and the scumbags. But just notice here, $25,000 is the per violation statutory penalty. That is pretty high. Okay. As we go down here, it's interesting because it can get even higher. It can be a person that knowingly uses or has used a method or practice that targets vulnerable individuals. Okay, that was that definition you gave us earlier, Arbel, right? The folks who are over 75 and have disabilities. If you're like a special scumbag that is targeting people, right, elder abuse, people who have limited capacity, and you're being a real super scumbag, right? Then you can go up to $75,000 for each violation, $75,000 per violation. Now, those of you, for instance, in like the Medicare vertical, okay, this is something that you guys need to be thinking about. Obviously, if you're selling Medicare, and the consumer is asking for information about Medicare, we've got to think to ourselves, is that going to constitute something that's illegal, right, in Michigan under the anti-lead generation rules? Assuming we get clarity around consent, I think you're probably going to be okay, but you got to think long and hard. Like, what if you're converting from, say, a Medicare lead to a final expense lead, right? That might be not viewed very favorably. And if it's not, again, this special enhancement for vulnerable populations is not there for fun, right? It's there because the state AGs was looking for it. And I would anticipate that they're going to be taking a really close look at calls to seniors out there in Michigan. All right, so let's move forward now to the private right of action, which you have to kind of scroll down a little bit for. Oh, actually, there's one other thing that you guys should be aware of, which is kind of weird. If the Attorney General has reason to believe that a person has information or is in possession, custody, or control of a document relevant to an investigation for a violation of the Act, the Attorney General may serve before bringing the civil action, okay, a written demand to appear and be examined under oath. This bill gives the AG's office the ability to depose you before they sue you. They can, and that's true even if you're not the target of the investigation, right? Let's say, it's going back to the solar warehouse. They want to investigate John's solar. They think they're providing false leads to Bob's call center. They can depose Bob's call center, bring him in and be like, all right, Bob, tell me everything you know about John's solar, right? And they can do that before they even file suit. So this is very different, right? Usually you have to have a suit pending. You have to have a subpoena. You can certainly do a civil investigative demand, but generally those are directed, more to the companies that are actually the targets. And you don't really see depositions, right, in a CID, but now you can. Very fascinating. To me, that's a really interesting change. So again, the Michigan's AG's office, I can promise you, like, this wasn't just cobbled together by some staffer, right? The AG's office was, there's no doubt in my mind, liaising with the legislature on this and asking for this power. So it's really interesting to see this. Okay, so we're finally scrolling down now to the part where we get a private right of action. There's a lot of other little pieces here. All this has to do with what the AGs can do, bad things. Section 35. This is an interesting, very interesting provision. A person that suffers loss as a result of the violation of this act may bring a civil action to recover one of the following, whichever is greater: actual damages plus reasonable attorney's fees, or $1,000 plus reasonable attorney's fees per violation. So the question earlier, if they violate the lead generation provision, can they sue for it? The answer is yes. It's part of the act. Any violation of the act can lead to this $1,000 per violation penalty plus attorney's fees, folks. And again, the Florida bill is a little unclear as to whether or not attorney's fees are enabled. This bill is clear. Attorney's fees are enabled. So, in in the TCPA context, right, attorney's fees are not allowed except for in class actions, which is why you see so many class actions, but you also see fewer lawyers trying to bring these cases because only the creme de la creme out there of attorneys can practice complex litigation in federal court, which is what is required under the TCPA. But under the state bill in Michigan, that's not going to be a barrier to entry. Any old schmo can file an individual suit seeking $1,000 for one violation of the act, right? They don't have to try to make a class action out of it. They can show one violation of the act and then get their attorney's fees. It's like the FDCPA. We see, how many of those little nuisance cases you get, and you have to pay the little $4,000, $2,500 in attorney's fees. It's the same thing here. You have to pay the $1,000 and you have to pay fees. And again, it makes it harder to defend these cases because think about it. Like in a TCPA case, it's the individual suit. You can go to the mat. Let's go try the case. What's the worst case scenario? $1,500, $3,000, right? $4,500. But in a action under this statute, you go to the mat, you owe them $4,500, plus you might owe them 6 figures in fees if you lose, right? Really interesting statute, and it will result in drastically different litigation tactics in Michigan than you get at the federal level. All right, I know we're a little bit over time, Arvel. I wanted to go under time. I'm willing to stick around for a few minutes to answer questions if anyone has them.
Awesome. Well, thank you, Eric. Yeah, let's again, if you got any questions, if you wanna, again, we got a bunch on here. A lot of them is just, going to be your interpretation of what it says. How do you interpret this bill? I mean, one was like if an SMS, I'll go through like, say 5 questions and we'll just call it because there's so much and it's still pending. So, but the question from Steve asked earlier about an SMS message, let's say sent by an AI SMS bot, like what could be disclosed? Does that have to be, disclosed, the solicitor's true first and last name?
Yeah. Oh, that's a really interesting question. I mean, the spirit of the bill would seem to suggest, I mean, at a minimum, the solicitor has to be identified, but it seems to suggest you have to identify that you're a bot, right? Or no. I mean, honestly, I think that this bill would require disclosure of the fact that this is a bot. Hi, this is Bob, your automated chat bot. I don't know. That's a really interesting question. Really interesting. And unfortunately, there's not a clear answer to that, but that would be my guess.
Gotcha. Thank you. Next question. Edwin asked, let's see, when you were talking about the ID, caller ID and spoofing. And so would cell phone providers and apps that change your display, to spam be considered in violation? That's interesting. That's
an interesting question. I mean, obviously, I like it. It's kind of like a snarky retort. The answer is probably, that's not what the bill contemplates, but, depending on the definition, which I have to go back and kind of noodle. Short answer is maybe. It's an interesting point, and maybe that will enable callers to sue companies that are labeling them as spam. They can sue under the Michigan Act for violating the statute. I don't know. That's a really interesting thought. I'll noodle that one. Good suggestion. What else we got?
Okay. Anonymous says, how could the local DID provisions be interpreted where I may have my contact center in a different state, but the representative in that contact center must be licensed in Michigan to perform that work in Michigan?
Yeah, I see that question all the time, right? Well, wait a second. Just because I'm physically not in Michigan, that doesn't mean that I'm not qualified to do work in Michigan, right? I've got a licensed professional, who's Michigan licensed. Look, I agree with you. I agree with you from a policy perspective. I'm not sure I can get there, though, from a strict reading of the statute, right? The reading of the statute is looking at the location of the caller, not the ability of the caller to practice any particular or to be licensed for any particular purpose in the state that's being called into. I think that's a great argument, and truthfully, I think it's a great constitutional argument, right, under the Central Hudson test. The law allows my agent to be licensed in Michigan and live and work in California, and the Privileges and Immunities Clause should permit that, regardless of your dumb bill in Michigan. But I don't know. That's a constitutional challenge. I mean, I like it. I like where you're going. This is why I like having these webinars. We can kind of think through issues together. But at the end of the day, that's going to be a pretty tough question to get a court to buy.
Okay. Yeah. So that again, you were talking about DBAs and a couple other questions on, Tony asked, what's the definition of a quote unquote real DBA when you mentioned, yeah.
Oh, yeah, sure. So again, the requirement is that the name of the company be disclosed. If you want to be super safe, you'll give the full business name as is recorded in Secretary of State or whatever. That's what the TCPA requires. Notably, though, that's not actually required under the Michigan bill. It doesn't say that. Instead, it's looking at a true name, a name of the business that is actually being used. So I guess the essence is what's a real DBA? I mean, it's a DBA that you're actually using, that you actually go by. It would be like my DBA is Troutman Firm, If I decided, oh, I'm going to call myself King's Hawaiian Bread Law or something for the day, or just to try to confuse somebody to call back. I mean, yes, I'm using it that day, but it's not my real DBA, My real DBA is I'm Troutman Firm. So hopefully that makes sense. I mean, look, if the essence of the question is, how much can we dupe a consumer? I don't like that question very much. But you want to be transparent, and I think the concept of this bill, again, striking balance, is to move away from the rigidity of you have to give the full name of the recorded LLC in wherever you're headquartered. You don't have to do that. You don't have to call yourself, this is Target Corporation, a publicly traded company, You can just say it's Target calling. And I think that's the right answer. But obviously you don't want to abuse that or try to abuse that, because the way the rule's written, it's definitely to prevent fraud.
Gotcha.
One last thing, since there's still have over 100 people sticking around. Again, by way of balance, under Section 39, we know the TCPA can be applied personally to folks. It's a garbage statute. It's terrible that there's personal liability, and even a low-level employee, the guy sitting at the call center that happens to be talking to the scumbag litigant can be sued personally, for their involvement in that call. The Michigan bill, although it does contemplate personal liability, folks, I mean, it's not as if you're going to avoid personal liability necessarily under the Michigan bill. It has an exemption for low-level employees, which I like to see, A low-income employee that's not responsible for the managerial, strategic, supervisorial, structural, policy, or other organizational decision-making is not liable under this act if the employee's violative action is undertaken pursuant to the direction of a supervisor, Finally, if a boss tells you to do something and you do it, again, on the TCPA, you're still liable. It's terrible. But at least in Michigan, you're not. So that makes sense, Someone is thinking this stuff through, and I like to see that. So anyway, we're way over time, Marvell.
Yeah.
If anyone else has questions, of course, Troutman@troutmanfirm.com. I'm happy to answer your questions for you. And we'll have more content on this. This is a big bill. It's a big deal. And we'll keep pumping out articles so on TCPA World and providing our analysis.
Awesome. Thank you. And again, everyone, we will be sending a recording. We will send the recording of this conversation, of this webinar, no later than tomorrow. We'll send it to all of you. If you have any questions, again, we'll send links to TCPA World. And as we publish information at dnc.com on this bill, any other updates that you need to know, definitely make sure you're subscribed to our list of alerts and our news, and we will keep you informed. Again, a reminder to sign up for the TCPA Florida Summit. You can go to dnc.com/events, and you can sign up for that. So we can make sure that you are in the know of what you need to know about TCPA and your business. So again, we thank you for being here. Thank you for your time, and have a great rest of your day. All right. Thank you.
Everyone.